Well, in law, a bill of particulars is, everybody, have you ever heard the expression, the nature and the cause of an accusation? Nobody's ever heard that? Who's ever been to court? Okay, you've heard that. Okay, the nature and the cause is what a bill of particulars is all about. What is the nature and what is the cause of the accusation? In other words, if somebody comes to you and says, well, I'm going to sue you for not delivering my cargo, you don't really know how to prepare a defense against that. Because the question is this cargo that was taken on a ship somewhere, thus admiralty law? This cargo that was taken on a truck over the roads, thus equity? Is this cargo that was on a military base? Thus we have federal jurisdiction in this. Was this cargo done with a state? Or maybe this was a private cargo. We don't know. How do we find out? The law provides, let me step back one more. It used to be that complaints had to be perfect, okay? The complaining party and the answer, they all had to be perfect. Then they decided there wasn't enough money in it, okay? So they said, and the government couldn't get over on you enough. So they said, okay, the complaint doesn't have to be perfect. In fact, it can be perfectly terrible. And it's okay if the defendant don't mind. In other words, doesn't ask for a perfect complaint. You ask for a perfect complaint by asking for a bill of particulars, saying, I don't know what the heck you're talking about. Please tell me what your jurisdiction is, what your venue is, what you're really complaining about, what type of law are we dealing with here, who are the parties, who are the real parties of interest. You say the state of California, who's that? You know, there's lots of different things. So a bill of particulars is merely asking for them to define what it is, what it is they're doing, where it is, where they're coming from, so you can prepare a proper defense. And until they give you that bill of particulars, you have no way of defending yourself. Therefore, you're without a remedy, and you can't do an answer. That's why the law requires that they answer a bill of particular when you make a request for it. Okay? Peter, upon receiving this thing with the name in upper lower case, went ballistic. She literally started yelling at this poor little clerk. What are you doing? You can't do that. You're doing this thing wrong, and all this other kinds of stuff. And the judge chewed her out, and they changed it back to all caps. So the reality is they can't prosecute you. They have to get you to buy into a fiction because they have jurisdiction over a fiction. Now this goes back, maybe in a little background here. This goes back to what's happened to this country and what's happened to our court system. Before the Civil War, we had constitutional government, constitutional court system, all that other stuff. I'm going to give you the Reader's Digest version of everything that's happened. But basically what happened is the southern states said that if Lincoln was elected, they're out of there. And so Lincoln was elected, and they left. They packed up and went home. Well, the northern states then packed up and went home too. Now, our Congress operates under the Roberts Rule of Order. The Roberts Rule of Order say that any organized body that doesn't set a date certain to reconvene is disbanded. So guess what happened to Congress? It was officially disbanded. So now we no longer had a three-branch government. We no longer had representation of the people because we had no Congress. And Lincoln did the first executive order. Executive order number 1 was done by Mr. Lincoln, okay, President Lincoln at the time. And what he was doing was he established military law. Martial law had to be established because otherwise we had chaos. So he established martial law. He was planning to reconvene Congress after the war was over. But as you remember, right after the war was over, somebody killed him. So he couldn't reconvene Congress. So he could stay in martial law. Just a little background on who did it, by the way. There was this guy named Booth. You probably heard of him. He was 6 months prior to his assassination of Lincoln, a guest on the ship coming from Europe for one of the big bankers called Warburg. And 6 minutes later, he shoots Lincoln. But interestingly, that the Secretary of State, who was in charge of the security, guarded all the roads, and who was, by the way, just coincidentally, deeply in debt to the banks, guarded all the roads around the place where Lincoln was, except one. Booth took it. I wonder why. He had people guarding Lincoln except for a certain time when Booth happened to show up. What a coincidence. You know? And he supposedly died in a barn that they all shot at and burned down, and a dead body. Isn't that convenient? It got cremated, so they say. All right. So he took off, went down the only road that was free, and then there's some body in a barn that they burned down so they can't recognize who it was. Yeah, right, he died. Okay, so anyway, this was the situation. We now have a government that is actually under military control. Then what happened was the departments were put into branches. We have the executive branch, the judicial branch, and the legislative branch, all under the executive department. And if you want to verify this, just go into any government building and look at that American flag in California. Look at that American flag in all government buildings in Arizona. Look at the American flag in all buildings in Washington State and any other state you want to go to. The prominent flag is the American flag, usually gold fringed. Under Title IV, Section 1, under the notes, it tells you that the flag of the United States is 3 colors. Of course, red, white, and blue with a red, 13 stripes, the red on top, red on bottom, blue field, white stars. Okay? However, it has this funny little note that talks about the fact that the gold fringe around the flag has no significance other than through the order of the President as Commander-in-Chief of the military. Oh, the gold fringe around the flag has only to do with the military? So what are all those gold fringe flags in those courts and in those government buildings? What are they telling you? This is military. Because the only significance in our titles, it tells you, is the gold fringe merely means that it's put there by the President and his capacity as the military, the Commander-in-Chief of the military. Okay, so you know what kind of government you're dealing with right now.
In all the United States federal jurisdictions like buildings and bases and anything, the federal United States.
That was Title IV, Section 1?
Section 1. Title IV, Section 1. Pretty interesting, pretty boring reading, really, but when you get down to the notes, you see that one little footnote that they tell you what the significance of the gold fringe is. And unless you really think about it, you know, because it sounds just like a little offhand thing, oh, it really doesn't mean anything. That's just put there by the President as the commander of the military, you know, just don't worry about that. Yeah, right, okay.
I know you've got an agenda to go on, if I'm with you so far, the flag with the fringe around it now, that's just there because the President said to put it there.
In the capacity as the military commander.
It's got nothing to do with representing you and I, the citizens of the United States.
No, it has nothing to do with you and I as citizens. It has only to do with the military martial law, okay, which is what President Lincoln established and was not able to unestablish before he was assassinated, okay. In fact, you remember Kennedy. Remember, he said about 10 days before he was shot, or 2 weeks before he was shot, he said that the office of the President is being used in a conspiracy against the American people, and he is going to tell them what that is before he leaves office. And he was shot. Now, understand also, he started printing U.S. currency. He had ordered that through presidential order, the printing of the U.S. currency. And what was the first thing that Lyndon Beans Johnson did when he became president after Lincoln was shot? What was his very first order?
$2, $5?
Cancel the printing of the U.S. currency. So let me ask you, why was Kennedy shot?
That was backed by silver, right?
Well, no, that's not important whether it was backed by silver or backed by gold or anything else. What was important is it wasn't Federal Reserve, okay?
U.S. money, yeah.
It was U.S. money, okay? That's right. He understood what was going on. He told the American people it was being used in a conspiracy, and he was starting to set it right. But he was assassinated. And Crook Johnson, the very first thing he did was cancel that printing of the money. Because after all, they understand that money, to be taxed, has to be worthless and it has to be theirs. Okay? And even the Bible, it says, what did Jesus say when they came and they tried to trick him to get him arrested? And they said, here's a coin. And he said, well, whose image is on that coin? And they said, well, Caesar's. He said, well, give to Caesar his things and give to God his things. Okay? Paraphrase. So that is true today. Who is on the currency we have? Okay? We have dead presidents. Okay? Well, give to the dead presidents their own stuff. Okay? But if you look at gold coins, silver coins, you know, there aren't any dead presidents on that stuff. There's constitutions, like the Constitution, there's Bill of Rights, there's the Constitution ship, Liberty Bell, Eagles, no dead presidents, because they have no right to that. Okay? So, understand the principle. and just to give you a little touch on me, I believe that this thing is spiritual in nature. That is to say, that there can't be something that goes for this long without some kind of spiritual connotation behind it, some kind of supernatural, you know, because I believe in God, so I also believe that there's a Satan. And there can't be this kind of uniformity and consistency in what's happening unless there is somebody who transcends the lifespan of people influencing what's going on. So I believe that there's a spiritual battle, and if you don't have the spiritual grasp, you're in a bad position. Because understand, the Bible talks about one angel wiping out 186,000 soldiers. Okay, so if one angel does that, you know, what do we have? Okay, we're in trouble. Okay, we aren't even close. So we have to understand that our battle is spiritual, and we have to, you know, approach it from that light. Ask God for His protection, and then go ahead under His protection. Now, yeah, spread the word. That's what He tells us to do. Okay, the Bill of Particulars. No, let's see. Where was I? I was giving us the background, wasn't I? Okay, so we have this fact that we are now under martial law. Okay, what does the martial law courts have jurisdiction over? What is their venue? Okay, there's things like venue, jurisdiction, things like that. Venue is a location. Okay, when I said that the government has legal authority in Washington, D.C., Guam, Puerto Rico, Virgin Islands, a military base, that's a venue. California, inside the borders of California, that's a venue. Okay, so venue is location. Where is the location that they can extend their authority? And the problem is military government can extend their authority only over military personnel and fictions, pretend things. Okay? So you have to become a pretend thing. That's why your name has to be in all uppercase, because they have no rights over us, the private citizen, because the private citizen is not in the bankruptcy. They're not in the military takeover, if you will, out of necessity, but nonetheless, you know, our civil government could come back if we could just have some money, because the Constitution says the state can't coin anything except for gold and silver. There's no gold and silver to operate in as far as currency is you know, used today. So our civil government can come back if we put back gold and silver. That's why you're not going to see it. You'll never see it as a currency around here, because they know that then civil government can reappear. All right. So anyway, that's what you're dealing with. A court system that is basically military in nature. Like when you go to traffic court, the laws or whatever they dream up at the time. Okay, they make a showing. You know, well, we'll pretend to follow some kind of law, Until it doesn't agree with them, then they just ignore it. But here's where the bill of particular comes in, okay? Because we do have in the Constitution, and this is why the bill of particular works, okay? It's the oath that all government personnel have to take to the Constitution. Because in the Constitution it says that not that you have a right to due process, but they have a duty to make sure you get due process. Okay, that's in the amendments. The Bill of Rights is not what our rights are, it's what their duty is in dealing with us, the private citizen. That's what the Bill of Rights is. For instance, the Second Amendment, what they call the right to keep and bear arms. It didn't say we had a right to keep and bear arms. What it said was that they will respect the right that we possess inherently to possess weapons. Actually, weapons is wrong. Weapons is a legal term, means something you're intending to use in a bad way. So we have the right to possess guns and rifles and other kinds of armaments like that. What's that? Mm-hmm. Well, if you look up weapons in the law dictionary, you'll find out that the code says that if you have a concealed weapon, okay, carry concealed weapon, and the waiver to carry a concealed weapon, you look up weapon. Weapon is something that is designed to be used offensively in a combat situation, okay? Designed. Well, let's look that up. You look up designed, and it says something with intent or purpose, etc., to be used in an offensive way, etc. So what you find when you put all these words together, you look up all the legal terms, that a weapon is something that you're carrying because you're planning to go out and harm somebody offensively, okay? They didn't do anything to you. You're going to go out and harm them. That's why the police all carry weapons. But what happens is the weapon is defined to be that which is going to be used in a wrong way. Defensively, it's not a weapon, okay? It's only be a weapon if you are going out and looking to use it offensively. But they don't bring that up in court because they lose. So that's why they don't want you to know that. But anyway, those are legal terms. So back on point here, the Bill of Particulars. The Bill of Particulars is that item. Remember I said before that they decided to break this down into a couple of processes. First you had to do it right. Then they said, no, you can't make money that way. So now you can do it wrong. And it's up to the defendant to ask to have it done right. And then if he asks to have it done right, they have to respond to what you've asked. And if they don't respond, then this happens. Okay, this is California Code of Civil Procedure. Under Section 454, when you look up Bill of Particulars in the California Code of Civil Procedure, it sends you to 454. 454 is entitled Pleading Accounts, Delivery of Copy After Demand, Exclusion of Evidence, Further Account Verification. What you find when you read this thing is that if they don't answer your Bill of Particular, their evidence is excluded. So if there aren't any evidence, who's going to win the case if they can't present any? It's a simple thing, okay? So the Bill of Particulars is that thing.
That puts you back to where they originally wanted to change it.
Yeah, well, it puts you back where you should be, okay? But what's required is for you to ask as a defendant, because the court operates on presumption. Virtually everything is presumption. Because if, after all, if they got this fiction that's spelled out, it's all uppercase, so we don't really know what it means, but they pronounce the uppercase letters. You know, is abc here? Well, this one they can pronounce because they got vowels in the right spot. So is James here? James Mattatall? If I say yes, what have I said? I'm the fiction. I want to hang my body on whatever this fiction is being charged for. And I'll sacrifice, just like Jesus. Jesus came and says, I'll hang my body for all the sins of the world. I'm saying, I'll hang my body for this fiction. I think Jesus did the better job. I wouldn't hang my body for this fiction, you know. So, but that's the way it works. Okay. So he says, He's trying to get you to be the fiction in court. Your choice is to say, yes, I am, or no, I'm not. And if the judge is persistent, he's going to continuously try to get you to be the fiction, okay? And I'll show you how that works in a minute. But first, let's get to the bill of particulars. Okay, now, you're charged, okay? Traffic tickets, all traffics are criminal, okay? All traffic stuff is criminal, or somebody files a complaint on you or something like that. We want to know a couple of things. First of all, anytime somebody has an attorney write it up, they're going to put your name in all uppercase, okay? Especially in the caption where they do it for the court. Now, you probably want to know something. What do you think you want to know? I mean, I've got the advantage because I got the bill of particular here, but I'll give you a chance to answer the question if you think you might have some ideas. But personally, if you get somebody serves something on you, let's say a traffic ticket, okay, we're all familiar with that. The officer writes out a traffic ticket, says sign down here, you put your name on the bottom, okay? Your name's always in upper cap, or pretty much always. They never spell out your middle name. In fact, I got a ticket once, and the officer was putting out my name. He says, what's your middle initial? And I said, my middle name is Arnold. And he says, oh, okay. He says, well, what's your middle initial? And I said, well, my middle name is Arnold. He skipped my middle name, didn't even put the initial down. Okay. I mean, Arnold. That's a hard one? I mean, don't we know what that starts with? Oh, A. Okay. Yeah. Yeah, he couldn't figure that out, I guess. Actually, he just couldn't put the middle name down there. So he figured, well, I'll skip the whole thing. After all, it's all fiction anyway, so who cares? But he doesn't know that, really. He only knows that he's supposed to put down the, you know, the name in all caps. He doesn't know why. Other than he's told that it's more legible that way. So he thinks that that's what he's doing it for. Yeah, the police officers out there are not, most of them anyway, are not out there really trying to get you per se. At least they didn't used to be. But there are some which feel that they're out there to get you. However, it don't matter, because after he writes this thing out, he puts down the charge, okay, 22,350, okay, exceeding the basic speed laws, which you can win that on its merits, but we won't bother with that. So he got 22,350, exceeding the basic speed laws, 4,000, lack of registration, you know, it just goes on. So we have these charges. Now, what's he put down the ticket? Puts your name, puts an address, he writes a vehicle code section number, and maybe puts a brief description what that's about, speeding, okay, and then he signs it down the bottom and says you agree to show up, okay, with this all cap name, agrees to show up anyway. So now what do you think you want to know about that? Okay, the bill of particulars is for determining the nature and the cause. Okay, two things. That's what you want to know. What is the nature and what is the cause that's being brought before me? So, the nature and the cause. Let's take a look at what you have to do first. Remember I said that the court presumes an awful lot? The court presumes a lot. If you give them a word, let's take a word like one. How many ways can one be used? I'm the first one. It's the number one. There's only one of a kind, right? I mean, there's lots of ways it can be used. Okay, so you put the word one down in a sentence. How can the judge define that? Any way he wants, right? Well, let's take a word like, let's see. How about pleadings or case or an action? If you use pleadings, case, or action, which one are you talking about? You say, well, in the action here, or in the pleadings that they filed, or whatever. The question is, what do you mean? And if you don't define it, can he define it? Sure he can. That's his job, right? So the first thing you have to do is define what you mean when you talk about certain things. So the judge is not free to define them the way he wants to. So we give a definition section. In this case, it's an indictment. And it says the word indictment means indictment or charging instrument filed in case number, and this is their case number, in the South Bay, Orange County Court. Okay, the word pleading means the indictment as described in definition 1. The tribunal means the court, and the words case, action, proceedings mean the action or procedural brought by the indictment in this case. Now, here's a real good one. The word demandant, because in a bill of particulars, you're a demandant. You're demanding an answer so you can know the nature and cause. The word demandant means, and the name is spelled in upper lowercase, okay? The word plaintiff means people versus, and that's the way they put their caption in there, okay? Or it's counselors, agents, assigned, principals, predecessors, etc. The word defendant means, and we got the person's name in all uppercase, exactly the way they did it, okay? Now, we got a whole bunch of other stuff there too, but let's get to some of the questions we ask. We got about 11 definitions. Okay, questions. Now the first thing, we've done two important things, which have to do again with the spelling of the name. We got the demanded, my name's upper lowercase. We got the defendant, and that name's in all uppercase. Okay? First question, what is the true and correct Christian appellation or proper name of the demandant? Please state the complete nomium, paranomium, cognomium, and use proper upper lowercase spelling. So in other words, we said, I'm the demandant. Now we defined what our name is, didn't we? And we said, okay, how do you spell my name? Right? As the demandant. Now if they spell your name different than the way you spelled it, don't we have now a cause of action of our own? Because they're saying you're different than who you said you are. We've got what's called a controversy. Controversies are what cases are made of. Because until you have a controversy, there's no case. It's just slam dunk. It's administrative proceeding. It's what you see happening in traffic court every day. Because there's no controversy in traffic court, right? They say, hey, is Jim Mattatall there? Oh, yeah, that's me. Come on up. Come on up to the shears. You walk on up there. I mean, there's no controversy here. Oh, did you do it? Oh, no, I didn't do it. Okay, well, we'll set it for trial. We come in the trial, the police officer sits down there, well, he was speeding, he was doing this, he was doing that. Oh, I wasn't doing that, I didn't do that, I didn't do this, I didn't do that. Okay. Well, first of all, what is what you're telling? What is that? Is that evidence or is that hearsay? Hearsay. What is what the officer is saying? Is that evidence or is that hearsay? Evidence. The officer, what he says is evidence. What you say is hearsay. Which has the stronger weight in court? Evidence. Guess who wins? Okay? Your word against his. Guess who wins? Hey, if it wasn't, if that wasn't the case, then they would need witnesses, wouldn't they? It's just your word against his. How can we decide? But that's not the case. He says is evidence. What you say is hearsay. Okay? Unless you can get enough witnesses to establish what you say is evidence, and thus can overcome what he says. Or you can bring up facts or circumstances that he'll agree to, which will do it. That's why I said that the 22-350, which is the basic speed laws, you can win that if you're doing less than 65. Anyway, because the basic speed law has nothing to do with posted speed. It has to do with condition of the road, the weather, the width of the road, the people who are on the road, the cars that are on the road, and visibility and things like that. Nothing to do with weather. You ask them those 7 questions, And if he says, yeah, it was good, it was okay, it was fine, it was da-da-da-da-da, you won. Because you weren't in violation of any of them. So why'd you write you a ticket? It has nothing to do with speed law, okay? But that's how you can do it on the merits. We don't do anything on the merits because then we have to agree to be the fiction and all this other stuff. So, back to this. So the first question we ask is, how do you spell my name as the demandant? Well, it's upper lowercase. Okay, now the next, what is the true and correct spelling of the defendant's appellation in the pleadings? Okay, so now their defendant, I mean, they wrote it out, they ought to know what it is, plus we've defined what it is. So that's all uppercase. Then, does the plaintiff claim that the demandant and the defendant are the same person? Are they the same? If they say yes, then we say if the question number 3 is yes, then what facts were relied upon to make that claim? Ooh, that's a hard one. How do you make a claim that I'm CBS or NBC or ABC or any other C's, okay? How do you make the claim? Well, what facts do you rely upon to say that I'm this person? Well, they didn't rely on any facts. They were hoping you'd just acquiesce. So the judge could presume that you agreed that you were this fiction, and they could just prosecute you. Okay, so they have a hard time answering that one. Okay, does the plaintiff claim that the demandant is a juristic, legal, or statutory person who spells demandant's name in all capital letters? Does the plaintiff claim that the demandant is neither a normal person nor a lawful inhabitant of the premises of the jurisdictional venue of the organic California state? Because they don't operate in the organic California state. They operate in the military venue, which is a juristic fiction of California. It's the state of California, which is a corporation. Okay. Okay. And let's see. If the plaintiff claims that the demandant is a statutory juristic person, what facts does the plaintiff allege to support any assertions that the demandant is an artificial, juristic, or statutory pleading, or person, I mean? Are the pleadings in this case brought in the appellation of the demandant? I mean, aren't those things you'd want to know? Hey, did you bring this thing in my name? That's what you just asked. Did you bring this thing in the appellation of the demandant? Well, of course they didn't. Okay. Do you think they're going to have a hard time giving you the nature and the cause of the accusations that you're being charged with? You better believe it. What will more than likely happen is they will not answer. Now, I'm just down to question 10, okay? And we have 48 questions in this one. Now, I've knocked this down from one that had 84 questions, okay? But yeah, you can ask them anything, okay? Just as long as you don't get into the merits of the case. You just want to deal with the issue of the nature and the cause. You know, what venue you're in, where you're coming from. Those other questions I didn't cover those issues. You know, where are you guys located? What venue are you coming from? Where is this charging instrument coming from? You know? So, they don't answer.
Oh, they won't answer those kind of questions.
I've only heard of one answer, and they didn't put a definition section in, and the questions were so poorly worded that they could have said anything, and it wouldn't have made any difference at all. Okay? So that's the only time I've heard them answer. Yeah. So, now they don't answer, but also understand that part of our demand is they have to answer every question. And if they don't answer any question, any one question, if they don't answer any one of the questions, it's considered a non-answer to all of the questions. Okay? So, because otherwise they just pick and choose. We'll answer this one. Not going to answer that one. We'll answer this one. Ooh, geez, I can't answer that one. Nope. Okay. Answer this one. Okay. Otherwise, they just answer the ones they can answer without a problem. Who's the defendant? Oh, I can answer that one. All caps. Who's the demandant? Yeah, skip that one. Okay. Are the two the same? Well, we'll skip that one. You know, what are the charges? Oh, okay, that's this. Okay. So, if they don't answer one, they've answered none. Okay. Then we put in a notice of fault. which is called a timely private notice of condition of fault for failure to respond to demand for bill of particulars to determine nunc pro tunc, that's from the beginning, that's what nunc pro tunc means, the nature and the cause of the proceedings as it applies to demand it with affidavit and verification. Then we do the same thing. We set up some facts, okay? Demand it privately served upon you a true and complete copy of the bill of particulars, et cetera, okay, and the date that it was done. It says, notice of the demand was filed in the above case on or about the 5th day of the 2nd month of the year of the true God, 1997. You were granted 10 days to respond or request in writing extension of time if good cause was shown. There's been no respondent from you served upon the demandant. Okay, the period has expired, additional period of 22 days have gone past, you still haven't responded. As of this day, there's still been no response from you to the demand. Okay, you're in a condition of fault. Then if we describe what that condition is. Okay. We tell them that we can go after them for violation of their oath of office, et cetera, et cetera. And then we define things again. The following definitions apply to this answer contained herein. And we define everything again. And then we say, notice of your stipulations pursuant to fault. In other words, we said, okay, you didn't answer, so here's what you stipulated to. Here's what you've agreed to by non-answer. The true and correct Christian appellation and proper name of demanded is. We put it down there. The true and correct spelling of the defendant's appellation in the pleadings is. We put that down. The plaintiff stipulates that the demandant and the defendant are not the same person. Oh, okay. The plaintiff has no evidence that demandant and defendant are the same person. He stipulates to that. The plaintiff does not claim that demandant is a juristic, legal, or statutory person who spells demandant's name in all capital letters. The plaintiff stipulates that demandant is a normal person and a lawful inhabitant of the premise of the jurisdiction venue of the organic California state known as California Republic. The plaintiff stipulates that there are no facts in support of any assertion that the demandant is an artificial, juristic, or statutory person. The plaintiff stipulates that the pleadings in the above case are not brought in the appellation of the demandant. The plaintiff stipulates the demandant is not a real party of interest in the proceedings in the above case and that the demandant has been mistakenly held in the above case and should be discharged from the above case. Okay? They're stipulating to that. You should be let go. That's nice of them. The plaintiff stipulates that all further issues raised by the demandant in the demand are irrelevant and immaterial in that the demandant is not a party to the proceeding above case. Because that wouldn't be relevant to you then. If you're not a party, what the heck? Who cares about everything else? Okay? And we do proof of service verification, etc. Now, here's what happens. Okay, you serve all this stuff. One of a couple of things happen. One possibility is that you call the court that day, you're to show up, and your case is not on the docket. Not there. Where'd it go? I don't know, they told you to be there, but they haven't even made arrangements for you to show up, okay? So they've dropped it from the docket. Another is they left it on the docket, and they're going to want you to come in or hope that you won't come in so they can do a failure to appear and start another action, okay, which would just bring a bill of particulars from you on that from the, against the judge. The other is that you show up, okay? Well, these are usually at arraignment situations, so now you're at arraignment. You're at the arraignment with the court, and the judge says, well, ours, you know, is Jim Mattatall here, James Mattatall here. And I'd say, well, I'm here in regards to this case, but I don't wish to identify myself at this time. And he can either try to pursue the issue, am I James Mattatall? And if he does, let's say he says, well, are you James Mattatall? And he says, well, Your Honor, says, I believe there is something in the record which properly identifies the parties. It's a bill of particulars and a notice of fault. And you'll notice that the plaintiffs have stipulated to the fact that I'm not a party to this case. So what is it you're asking, Your Honor? I say, well, you'd probably look at the notes and say, I don't see it here. Of course, you have a copy, which you say, well, I have a copy of it here, Your Honor. Would you like to see it? which now he has a copy, okay? Of course, you have served one on the clerk. And if she failed to put it in the record, that's their problem, because you also got it date stamped. So you've done service on the clerk saying, hey, this is in the record, this is what I gave him, because this is private service, understand. This is not public service you're doing for this thing, because this is private, because you don't know if you're a party. You can't do public service when you're not a party to the action. So it has to be private service, because you don't know if you are or are not a party at this point. Until you know, you can't do public service. So you can just do private service and put people on notice, like the clerk and stuff like that. The notice you give to the clerk is a little statement that says, this is notice. I've served a bill of particular on these people through private service. Here's a copy of the bill of particular. Here's a copy of the proof of service. Here's verification. Here, I'm giving you the notice. And then they say, well, we have to go check and see if this is okay to put this in. It says, no, you misunderstand. I'm not asking you if you'll accept it. I'm telling you, you've been put on notice, okay? So do you understand the difference? The difference is, I don't care what you do with it. You've been put on notice. Now, you do what you better do with these things, because I don't have the oath of office to do things right. You do. So I suggest you follow your oath of office and do with this form what you're supposed to do. Bye. And I'm out of there. That's if I'm doing the service. You never do your own service, okay? You always have somebody else do service for you. That's because you want a neutral third party who can verify that things were done, who would have no interest in lying. Okay? That's the way it works. Which means anybody who's not involved in the case. So, now you're in front of the court. Okay? We're back there again. And you give him a copy, and he says, well, yeah, I see this, but, how do you plead? Well, Your Honor, is it proper for somebody who's not a party to plead to a case? Well, I want to know how you're going to plead to this case. I have to know. If you don't enter a plea, I'm going to enter a plea of not guilty. Well, Your Honor, is it proper to enter a plea of not guilty for a person who's not a party to a case? By the way, Your Honor, is this a court of record? I hear that all criminal cases have to be in courts of record. Are we making a record here, Your Honor? And if we are making a record, I would like a copy at the end of this case, or at the end of this this time that we have here. Who would I talk to about that, Your Honor? Well, if it's not, by the way, all criminal cases have to be courts of record, okay? It's automatic. It's in the statute. They must be courts of record. So if he doesn't know, which many times, well, I don't know, I think it's court of record. Well, gee, I don't know. Well, it's very simple. Is somebody taking it down, or is somebody not? That determines whether it's a court of record. Is somebody recording what's being said, or is there nobody recording what's being said? You think the judge would know since he controls everything that goes on in that courtroom? Sure he does. He knows whether it's a court of record. But anyway, they may try to, well, gee, yeah, I think so. I don't know. That's what happened with one guy, the commissioner. Yeah, this is a court of record. I think it's a court of record. I don't know if it's a court of record. And he got up and he walked off the bench. So, I guess there's no record now. The judge isn't there. Case dismissed. So, anyway, so if he says, if he wants to press the issue and say, well, I'm going to set a court date for you to show up, say, well, excuse me, Your Honor, who am I that's being ordered to show up? You notice that I always ask a question. If you tell the judge something, you can be held in contempt, okay? So you never tell the judge anything. You ask him questions. And by asking the questions, you tell him what you want to tell him, okay? Because what do I want to tell him? Bonehead? I'm not a party here, okay? What are you talking to me for? So I ask him the question. Well, Your Honor, is it correct for somebody who's not a party to enter a plea? Didn't I say the same thing? Yeah. But I did it as a question, so I can't be held in contempt, okay? So no matter what he says, I always ask a question. Well, you show up here on such and such a time. Well, Your Honor, who is it you're ordering to show up here? Well, I'm ordering Jim Mattatall to show up here. Is he in the court somewhere? Well, I don't care. I want him to show up. He says, well, who are you giving that order to, Your Honor? Case dismissed. Or, okay, it's over. Get out of here. Bailiff, take him out if he talks anymore. Take him out anyway. Okay? So, I mean, these are the things that'll go down. And if they have a court hearing, then you show up and, I mean, it's going to be a court of record because that's the first thing you're going to ask. Is a court of record? You know, the judge pointed to me and he told me to show up. And now, if the prosecutor speaks, by the way, after you have a bill of particulars, let's say he orders you to go in and go ahead and do this little pretend trial. And at this pretend trial, if the prosecutor's there, he has to be there, but if he's there and he says anything, you immediately put all the attorneys on notice, the bailiff and the judge, that he is in violation of his oath of office, he's committed a felony, and you want all their names and addresses as witnesses to the violation. And you go to the first one, you ask, okay, what's your name? Suddenly, like rats, they leave the place. It gets barren. All the attorneys scatter. They don't want to be a witness against their fellow fellow attorney.
Why can't the prosecutor speak?
Because he has not answered the bill of particulars. And he has an oath of office and to the Constitution that requires, and as well as, by the way, under the Business and Professional Code, which is where you get to what's called the DRs, or the rules of conduct for attorneys, that he will protect your rights. And one of your rights is to know the nature and the cause of the charges. And if he is not telling you what those nature and causes are, and he tries to speak in court to do anything other than say, this thing's dismissed, we don't want anything to do with it, okay, then he is trying to prosecute you knowing that he has failed to give you the nature and the cause and violating his oath of office, which is a felony. Okay? And guess where you go from there? You go to appellate, and you file what's called a demand, or not a demand. It's called a. God, it left me. It's called a declaratory. You ask the appellate court for a declaratory judgment. You ask the court, and what you're asking the appellate court in the declaratory judgment is, did what they did, was that due process? In other words, what they did, was that right? Was that right for them not to tell me the nature and the cause of the charges being brought before me? Was it right to try to prosecute me without knowing the nature and the cause? Well, what do you think the answer is? Absolutely not. Now, that the answer is absolutely not, you can sue them for violation of their oath of office, civilly and criminally. Probably won't get them prosecuted criminally, but you can go after them, but you can always ask for it. And now you've got a judgment from the appellate court saying what they did was wrong. What's the first thing that happens in Title 42 is when you go after government personnel? What do they always file? Does anybody know? They always file the 12b-6. Pay the state a claim upon which relief can be granted because we're immune. And what's the assumption of the court? The government always does it right, and government personnel are just doing their job. Now, when you have a notice or an order from the court that says what he did was wrong, guess what presumptions don't exist? The government does it right, and he was doing his job. They don't exist anymore. So guess what he can't even file? He can't file a 12b-6, failure to state a claim, because we've already got a court that said what he did was wrong. What he did was wrong. He can't be let off the hook. Yeah.
Have you ever been to Dave Miller's seminar?
No, I've never been to Dave Miller. I do know about Dave Miller, though. Okay. So that's where you go at that point. And with that, you can then come back. They can't throw it out for the 12b-6, the failure to state a claim. And now it's just a question, and you've already got a court that said he's done wrong. So what do you think the defense is? There is no defense. The court's already said what he did was wrong. There's no defense. It's only a matter of how much. Okay? That's how you proceed. Now, let's talk about, that's with government, let's talk about private parties. When a private party, say a foreclosure, say they're going to sue you because they tripped over your tree stump, an auto accident, other things like that, how do they file the charge? Isn't it all uppercase? Well, don't you want to know the nature and the cause of what they're charging you for? You bet. Then in a civil action, it's called a statement of clarification, okay, or a more definite statement. But it's just bill of particulars, same thing. And you ask the same questions. Well, you know, you got this name in all uppercase. My name is spelled this way. You think they're the same person? It's the same person. What facts should you rely on to say they're the same person? You know, they can't proceed, and if they do, you can sue the attorney, and you can sue the judge if he tries to prosecute the case. Because after all, they've got to answer those questions. That's what they're supposed to do right in the first place. But they don't have to until you ask for it. And that's why the government controls education, so you won't even know to ask. And they tell you to hire an attorney so you won't be properly taken care of. Because, by the way, an attorney and a judge, or attorney and a lawyer is not the same thing. You know that?
No, didn't know that.
An attorney is somebody who has a bar card, has taken the bar exam, and has the license, which is not really a license. It's just I have my private membership in the bar, and then these military courts, who are full of bar lawyers, called judges, will allow their fellows to practice there. But they can't deny you as pro pers, what they call you, which you're not, or pro ses, which they call you, which you're not, to go in. But so they just treat you rudely. Yeah.
I went to a guy on College the other night in Las Vegas. He got into that, and he was talking about there's a difference between counselor in law and at law. You would be a counselor in law, and you can legally do it and go in.
And you can be assistants of counsel. Okay, so an attorney is somebody who has a bar card. A lawyer, somebody who doesn't, who practices before the federal court. So you can practice before the federal court if you just get educated. You don't need to pass any bar license or bar schooling or anything else like that. Yeah, it's kind of neat, but most people aren't aware of that. So anyway, let me see, where was I? Private. Okay, so you can do the same thing in the private arena and deal with the same issues. Now, if you're already in the middle of a case, you can always file a bill of particulars, because here's the question you ask if they say it's too late. When is it ever too late to exercise your rights? When is it ever too late to have any rights? When is it ever too late to know the nature and the cause of what you're being charged, so you can legally and properly defend yourself? When is it too late for you to be able to defend yourself? I don't think that it's ever too late, because you're always supposed to know the nature and the cause, because that's due process. And one thing that you mentioned, Miller, one thing that Miller said, which is really good, he talks about doing things backwards. Okay? What's that?
It's like a mirror, looking in the mirror.
Yeah. Well, what's due process? It's process due, right? So due process is merely that process that you're due. And if they don't give that which you're due, there's a violation. So the process due is what you're due in court, what you're allowed to have, what you're allowed to do. And that's important. Okay.
The last I heard was that they no longer are paying out for the Title 42s, but what's happening is that these attorneys and judges and bailiffs are being nailed into a little corner and they can't get out.
Sure, well, they let a lot of the Title 42s sit for years. I know Randy no, Rick Schramm
Several of them. Yeah,
has,
got one.
yeah, he's got one that's been there for years and years and years, and they don't want to move on it.
They won't.
And so there's got to be a way to get them to move on it, and that's what that's one of the things they're working on now. But anyway, a lot of these things are being settled when they don't ask for a lot of money. They ask for $50,000, $100,000, that kind of stuff. A lot of them are settling out of court because it's a heck of a lot cheaper to give you $50,000 or $100,000 than it is to pay all those attorney fees. And there's so many, what's the word? There's so much tortfeasors out there. That term is what the courts call the police officers, okay? They're just a bunch of tortfeasors out there. A tortfeasor is someone who's out there committing torts, committing wrongs. He says, you know, there's just so many tortfeasors out there that, you know, you'll have plenty of cases. And it's not as though you won't have any chance to go to court. Heck, you can troll for trouble, okay, in your car and create your own situation.
You just need to stick your neck out there.
Yeah, just go out there and act normal, and you're in trouble. Okay. So anyway, there's a lot of stuff we could go into, but I think that's probably good enough, because that gives you overall of the Bill of Particulars. Should be a framework that will allow you to at least know the process that you have to go on. By the way, here's something which I think, I don't get any commission on it, unfortunately. This book here, called Represent Yourself, okay? Represent Yourself in Court, How to Prepare and Try a Winning Case. It's printed by Nolo Press, and it's by attorneys, so you know they're licensed, Paul Bergman and Sarah J. Bergman Barrett. Okay? Nolo Press. And what it does is it tells you from the beginning to end how to prepare yourself. A lot of people don't really know what's going on in court. And most of us have found out the hard way what goes on in court. Okay? Well, there's an easy way. The easy way is to get this book. Okay? And you can find out what's going on in court without having to do it the hard way. And I'll just give you the captions of the chapters. And let's see, which are 19. It's got Go It Alone in Court, Courtroom and the Courthouse, Starting and Investigating Your Case, Pre-Trial Hearings and Motions, What You Need to Prove at Trial, the Plaintiff's Perspective, What You Need to Prove at Trial, the Defendant's Perspective. The nice thing about having both of those is you know what the other guy's trying to do. Okay? So you know what you have to overcome as the plaintiff, so the defendant can't prove what it is he needs to prove to stop you. Okay? And selecting the decision maker, that means how to throw the judge off the case. That's kind of neat. Opening statements, direct exam, cross-examination, closing arguments, exhibits, basic rules of evidence. That's very important. That's one of the fundamentals in court. Most people don't have a clue as to what rules of evidence are. You need to know what those are, because they determine whether you give something to the court, whether the court can accept it, or whether they can't, or they can just ignore it. Well, if you don't have proper evidence before the court, you're not going to get any decisions in your favor. Okay? So in making and responding to objections, organizing a trial notebook, which is very good, expert witnesses, when your trial ends, judgments and appeals, getting help from attorneys, hiring a legal coach, and how to do legal research. Okay? That's good stuff. It's worth doing if you're ever going to go to court, which I recommend everybody know. Okay? I got that one, by the way, at, Star Books? I think it's Star Books, over on Pacific Coast Highway. What's that? It's written by, the printer is Nolo Press. Nolo, N-O-L-O. Excuse me. N-O-L-O Press. And the attorneys, the authors, is Paul Bergman and Sarah J. Bergman Barrett. She's obviously married. Okay. So, interesting stuff in there. Now, anybody have any questions? Yeah, you keep going.
On your bill of particulars and everything that you've talked about,
Mhm.
what are you the plaintiff? And they've got your name in all caps, and like against the IRS or something like that. But then when you look back on your tax returns, they typed it, when you filed it, it was typed in caps too. Because, you know, like the accountant or something like that.
Now if I heard you right, you said, what if you're the plaintiff?
If you're the plaintiff in a court against
Yeah.
the IRS for like refund suit or something like that.
Okay.
And you look on your tax return and it's typed in uppercase.
Okay.
And you filed your pleading and, you know, for your complaint in the court already, and you've got it upper caps because they had it upper, you didn't know. Can you bring this same scenario in?
Sure. When is it right?
And ask them in admissions, admit that this isn't.
Well, is the time frame for your case expired? In other words, has the statute of limitations expired for you to be able to file the case in the first place?
No, I'm already in court.
I understand that, but that's not my question. My question, has the statute of limitations expired for you to file this type of case for these facts? In other words, there's time limits.
Yeah, no, what you're saying, if like on a 90-day letter, you file on a 90 day, then you can't go back and do it. In tax
Right,
court.
right.
So tax court, like you filed just before the 90 days, and obviously it's a year down the line,
Right.
you can't go back and do it. Is that what you're saying?
That's right. That's correct.
Probably not, because I've been in since '94 in the Federal Court of Claims.
If the statute of limitations has expired for you as the plaintiff, now understand tax court is merely administrative anyway.
I thought of something, because like I say, they extended it without my permission. I guess when you file in court, the IRS automatically adds himself 3 more years, so that means it would be open.
Well, if it's open, then what you can do is throw out your case.
They got a code on. No, I'm suing them for refund.
I understand.
But what I'm saying is,
If they've added 3 years to the statute of limitations for them or you to amend what you've done, then you can throw out your case, ask the court to dismiss your case without prejudice,
okay, so you can refile.
okay, and then refile it properly.
Because they've got on the master file a code 560, and when I looked that up, it said that it had been extended somehow.
Okay.
And I couldn't understand how I got it extended because I didn't sign anything, and what it was is they did that to cover themselves.
Yeah. Well, you can ask for it to be dismissed without prejudice and then refile it the next day properly. And then when they respond, when they put in an answer and it's all uppercase, that's not a response to your case, okay?
Okay, I understand what you're saying. And then in tax court, I already made a motion to dismiss. I only went, see, I didn't know all this stuff in the beginning because they're stealing my money. I didn't know what to do. Then they dropped $450,000 for a year. So I filed tax court so I could get a appeals hearing, which they'd never give me. Nobody would talk to me, so I could put it on tape. Then I figured, well, then I'll file a motion to dismiss tax court, and then they wouldn't dismiss it.
See, the proper way to get the proper way to get an appeals hearing is to send a letter to them requesting an appeals hearing. Okay.
Not this
Proof
area.
of service, registered mail.
Okay, I got
Okay.
certified to the district director.
I understand.
He's never answered a letter in 4 years,
understand.
and now he's never
But
here.
you send in a letter requesting an administrative hearing, okay? When they don't get it to you, because you give them so many days to respond, when they don't respond within that time period, let's say they give them 30 days. They don't respond within the 30 days. So you send a second letter saying, referring to your first one, hey, by the way, I sent a letter to you, you'd never respond to it. I've asked for administrative hearing as I'm allowed by law, and you haven't given me one. Please respond within 30 days to the second notice for an administrative hearing. Okay? Send it registered, proof of service. They don't respond to that. Then you send a notice to cure. Okay? Notice to cure saying, hey, I sent you 2 previous notices by registered mail. This date, this registered number, and you have not responded to any of them. This is your notice to cure to give me an administrative hearing, or the prima facie evidence will be that you're denying me my administrative due process rights and remedies. Right? Now, if they don't answer within that, you send a 4th notice called a notice of fault or default, saying, hey, guys, and you put an affidavit into it. And the affidavit, you swear to all the facts. I sent you a letter on such and such a date, which was your first notice requesting administrative hearing. You failed to respond in any way. I sent you the second notice, such as a date, by such and such registered mail. You failed to respond to that. I sent you a notice to cure on such and such a date, such and such a registered mail. You failed to respond to that. This is your notice of default saying you are in default. You have agreed to these things, that you're not going to give me an administrative hearing, that you're denying me my administrative due process rights and remedies, and that you're in default, and you intentionally and maliciously are denying me the due process rights and remedies that I have under law. Okay? And give them 30 days to respond to that. Now, after you do that, you don't need an administrative hearing, because you've got all it takes now to do a declaratory judgment. So you file it in the appeals court because the administrative agency has failed to do what they're required to do by law, and you ask the appeals court, is what they did right in not giving me an administrative hearing that the code says I'm required to have and that they're required to give me? And after I gave them 3 notices and a default and time to respond to all those, and they never did they give me due process rights and remedies?
Appeals court, you're saying Court of Appeals? Is that?
Yes.
Okay.
Okay, did they give me due process rights and remedies? Well, obviously the answer is no. Well, if they didn't give you due process rights and remedies, what happens to the action that they took? It's thrown out. What happens, and what is your complaint now? You sue them for the money that they didn't give you. And you've got an order from the court saying what they did was wrong. So how do you think a jury's going to listen to that? Well, here it is. This appeals court, which is superior to this court we're sitting in, has said what these people did was wrong. They should have given me my money back or give me a hearing, and they failed to do that. The law says when they don't do that, everything they've done is wrong, and I'm entitled to judgment. The judgment is I want my refund plus damages, et cetera, et cetera, et cetera. What say you, jury? What are they going to say? Ah, those appeals court people, they just don't know what they're talking about. I don't think so. Okay? There is no defense.
What is the statute of limitations in small claims court?
Small claim statute of limitations? Well, it's not the court that determines the statute. It's the action that determines the statute. And if you look in the Code of Civil Procedure, it has it's got time for filing motions, it's got the time limits for, it's got the time limits, there we go, statute of limitations. Okay, so what are we talking about? We got time of commencing action and other than for the recovery of real property. Okay, for other than that, we got periods described. We got 5 years, we got 6 years, we have 4 years, we have another set for 4 years, 10 years. Initial bonds, additional time, another 10 years, 3 years, 5 years, 2 years, 2 years. Let's see, attorney, 6 months, 90 days, 4 years. Okay, I've gone through 1, 2, 3, 4, 5, 6 pages of statute of limitations. Which one are we talking about?
Well, how about if your employer confiscated the paycheck to send it to the IRS?
Okay, you're talking about conversion. 4 years.
4 years?
The conversion, wrongful taking of property. Okay, what they'll try to classify it as is a tax issue, which is 6 months. Okay, however, it's not a tax issue, because for it to be a tax issue, you'd have to be a taxpayer. To be a taxpayer, you'd have to be an employee. To be an employee, you'd have to work for the federal or state government. And for them to be an employer, they'd have to hire you as an employee. In other words, be somebody who works for the federal or state government. And for them to pay you wages, you'd have to be an employee, they'd have to be an employer. For you to file a W-4, you'd have to be an employee and they'd have to be an employer. Okay? Yeah.
Phrase that question.
Well, rephrase which?
What would be, under law, what would be the limitations against fraud?
Against fraud? Well, fraud, now the difference with fraud is you have to prove intent. Okay?
What would be the limitations under law?
Fraud is 7 years. Okay? But,
Back to the very inception of the fraud.
well, it is. It's 7 years from the date of discovery.
Limitation against fraud.
Oh, yes, there is. 7 years from the date of discovery. If you say I'm wrong, prove it, okay? Because I can prove I'm right. It's in the statute of limitations, okay? 7 years from the date of discovery.
What's the name of that book that you just...
Oh, this?
Yes.
This is the Code of Civil Procedure for California, okay? Okay, there is nothing that has no limitation on it. Everything does. And the reason is because in this country, you can't be held forever under the obligation of something. I mean, it may seem like forever because 10 years is a long time, okay? 7 years is a long time. But there is nothing that has no statute of limitations.
I thought murder had no statute of limitations.
You don't, open case.
That's criminal. Actually, I was talking civil, sorry, didn't clarify myself. There is no civil action that has no statute of limitation. Yeah. And fraud, I assume we were talking civilly. Now, if we're talking criminal fraud, that's a different story. Okay, but no, not really. No, fraud is there's civil fraud and there's criminal fraud. And the criminal fraud and civil fraud have different weights of evidence to prove, but they both involve intent. Intent has to be established. That's why fraud is not something you want to necessarily claim unless you have all the evidence, all the indicia that would establish that there is indeed fraud on their part. Number one, they had to know it. They had to intend to cause the damage that was caused, or they had, and that was established either by them knowing it would happen or being willingly ignorant, quote unquote. In other words, not doing their due diligence to discover that if they did what they did, it would create the fraud. Okay? But anyway, you can look up fraud, go to AmJur, look up fraud, it's there. It gives you all the elements that you need to establish, and it describes them all to you.
So the IRS to be criminal and civil?
Well, for the IRS to be criminal, they have to do something criminal, okay? And the problem that we have with the courts that we have is that it's very hard to get them to prosecute their own, okay?
Case law overrules the real law.
No, well, case law doesn't overrule the real law. It depends upon your pleadings as to what it is.
What I meant was most judges, they do whatever they want. Most people don't know what to do.
Well, most judges do what they want because they define the terms. If you let them to define the terms, they probably can do pretty much what they want. If you go in there as a juristic entity, artificial creation, you have no rights. So they can do whatever they want. So it depends upon your pleadings. Your pleadings set the court. So based upon what kind of pleadings you put in, that sets the court. The flag in the court only evidences what venue they are operating in as a normal venue, okay? But your pleadings will set the venue for that court, or at least how they're going to decide the issue. They're going to try to get you out of any venue other than their own, because if they have you in any venue other than their own, you got rights. You know, they don't like that because now they got to do things right. Okay.
Seventh Amendment, where you go in and you plead the Seventh Amendment if it's over $20 to a judge, like in the Admiralty Court or Maritime Court. Is that a viable? Because I listened to somebody on the radio on the same station this gentleman was listening to, and he swears he's been in court and won, and his name's Hingston or something like that.
Okay.
And he's taken, he was doing the caps, the same thing. He said he's been in court and done that. And the guy seemed, you know, very knowledgeable, and he went through the Civil War and Robert...
Tell me what it is he did that we're talking about.
Okay, he went in, and he's in their venue and in their court,
Okay.
pleaded the Seventh Amendment to give him a judicial trial.
Okay.
Is that viable?
Well, did you pay in silver dollars?
No.
Because understand, the amendments have to be interpreted in light of when they were written. So the question is, did you use notes or did you use money? So if you use 21 silver dollars, yes, it's viable. If you did not, It's up to the judge whether he wants to play a game with you or not. Okay?
When you have a traffic thing and you give them a refusal for cause, both to the send the citation back and notice the court, and then you give a letter of special appearance, and then they send you a thing where the judge signs it, and they ask any future action or further action, and he says no action. Does that mean it's done?
Well, if they have no action, then that means they're not moving on the ticket. Okay? Probably gone to the black hole. But the one way to find out is to call the court, give them the reference number, and ask them if this is an active case or if it is been settled or inactive, or are they moving on it in any way or going to move on it in any way. Yeah, what's the status of the case? And once you find out the status, then you'll know.
Well, he signed it, or he put no action, and then he signed his name, and it's a wet signature, and then his stamp below that.
Okay. Well, it sounds to me like they've dropped it, but the way to find out is to call the clerk of the court and ask the clerk of the court, give them the case number, and say, you know, what's the status on this case? And if she says anything other than, you know, it's over, then say, well, I've got an order from the judge saying that there's no action going to be taken on this with a wet signature on it. Says, do you have a copy of such notice in the file? And see what they say. But I think you'll find that in a situation like that, it's pretty much a done deal. Okay?
If it wasn't done, what would be the statute of limitations till it would run out?
Well, you see, the problem you have is there's the statute of limitations, and then there's what they do. For instance, a bench warrant. How long do you think that's good for?
60 days?
Nah, longer than 60. Anybody have any idea? 90. Okay, that's a pretty good guess, but it's longer than that.
6 months.
No, not quite that. The bench warrant's good for about 140 days. Okay?
They renew it.
Why? Is there another? Did you do something wrong again?
No.
Okay.
Could they go ahead and...
Unless you did something else that was bad. It's like you're having a ticket, and they say, well, golly, gee willikers, you know, he came up, he took care of that. Let's write a new one for him. Okay, we're going to renew this ticket. Here, have another one. Here, we'll mail it to you.
So if they haven't picked the person up within that specified period of time, then he's scot-free.
That's right. However, what do? They leave it on their computers. And then any police officer 5 years, 10 years down the road, you get stopped for something, and he says, golly, gee willikers, I got a warrant for your arrest. Really? Well, gee, this is 5 years later. They don't talk about the statute of limitations. The officer don't know, but the Supreme Court has decided that 140 days is a reasonable time for a bench warrant to be executed on, and beyond that, it is null and void. Okay? Now, there's the law, there's what the court's decided, and then there's what they do. Because after all, if they can get these tortfeasors out there to go pick you up and carry you in and force you to pay the money, oh, hey, not the court's fault just because they inadvertently forgot to take it off the computer. That officer out there, he should know. He should, but of course he hasn't been told. He's been told just the opposite. I had one guy, I did appearance without appearance for an unlawful lane change, right? He did appearance without appearance. The judge put a $50,000 bail. Imagine that. Now, a couple of years later, he's going up to Northern California, and he does something. I don't know what it was. Maybe he was speeding or something. And the guy writes him a ticket and then goes back to his car, and then comes back to him. He says, oh, actually, he let him go. And he was going up, and the guy turned on his lights and then pulled him over again. And he says, there's a warrant for your arrest, and it's $50,000. He says, I've got to take you in. He says, $50,000, I can't do anything about that. And so he says, well, he says, I made that appearance, and this judge just had a thing against me and stuff. And he said, well, I understand, but there's nothing I can do. I got to take you in $50,000. So he took him in. He couldn't find any attorney who would represent him because all attorneys says, well, this has got to be personal with a judge, and we don't want to get involved for a $50,000 illegal lane change. And so what eventually happens about 2 days later, we were going to put some paper in and get him out, but they brought him up before the magistrate, and the magistrate says, illegal lane change, 50,000. Says, this is ridiculous. There's something wrong here, and we're not going to hold you. So they let him go, but they set up a date for him to appear at that court. So, but they didn't hold him. 50,000 for a little leg change. Yeah, come on, give me a break.
You remember that a few months ago on that $30,000 warrant? Remember the judge?
Well, there's been so many. I mean, all these huge. I mean, what happened to the constitutional thing saying no excessive bail? $50,000 for illegal leg exchange. But you can have possession of. You can shoot somebody and they'll let you out for $5,000. But if you change your car illegally, $50,000. Oh, that guy's dangerous. The guy with the gun, he's okay.
What would you report to be on expiration of a bench warrant?
Well, I would do the same thing.
Yeah, and
Well, I would do the same thing. I'd put in the bill of particulars. And first of all, of course, the real question is, why the heck are they stopping you in the first place? And why are you identifying yourself? Okay? The problem that you have, if you know there's something like this on the record, don't identify yourself. They're going to do a search. They're going to get your wallet. They're going to know who you are anyway. They're going to arrest you for obstructing justice, okay, interfering with the performance of an officer in the line of doing his duty and all this other baloney, which it is not. But you can always go and sue them, okay, for that stuff. But the point is, if you know that's coming down, don't make it easy for them, okay? Make them violate some stuff and make all that evidence inadmissible because what they did was wrong. They got to have probable cause. Why'd they stop you? Why'd they get this stuff? Didn't have probable cause. Thrown out. Yeah.
And that officer a public servant's questionnaire to fill out.
Well, he's hardly going to fill out a servant questionnaire standing on the roadside. I mean, you can ask him to do it, sure.
But is that not federal law that he has to fill that out?
Well, yes, but understand, there's a lot of things you can do when they do the tickets, okay? And a lot of things work in some places, a lot of things work in other places, and some things don't work in other places. So there's a lot of interesting and fun stuff you can do. But the first thing you have to be willing to do is go to jail, okay?
7 times over.
All right, good. The gentleman said that he's used the public questionnaire and it's worked 7 times for him. Sure. I'm familiar with the public questionnaire. Okay. Okay, he's going to hand some out to you so you have one. No, that's okay. But see, here's the thing. With the because of there are officers out there, and I was a police officer, so I know what's going on with these guys, and I know what their thinking is. Because of the fact that that some of these guys feel that there is them, the police, and there is everybody else. Everybody else is in 2 categories, the criminals and the citizens yet to be discovered to be criminals, okay? And there are officers like that. Fortunately, at least when I was on the force, it was a very small number, okay? But when I left, the peace officers, which is what I was trained to be, was being replaced, or the new people brought in were trained to be law enforcement officers, which they weren't trained to maintain peace in the community. They're trained to get those people to do what the law says to do. What does the law say to do? Whatever they're told they're to make those people do, okay? That's what it all comes down to, and that's what they're being trained to, and that's what this one world government and all this other stuff is all about, to get the officers' thinking switched from that of bringing peace to the community to that of bringing law and order to the community, okay?
He refuses to fill that out, which I can understand, and he takes you to jail then. Like you said, you can have fun and games with him at that point in time or after the fact. But he has still violated your rights.
Sure, absolutely. Due process. I mean, administrative, right there. I mean, you can also ask for an attorney. You're entitled to an attorney at all stages of an investigation. What's the first stage of the investigation? He turned on his lights, right? That's stage one. He pulls you over. He asks you questions. That's the first stage of an investigation. You're entitled to an attorney. Okay? They'll tell you you're not, but you are. I mean, you may have California codes or statutes that says you're not entitled to it, but the Constitution says you are. Okay? And any California statute that violates a provision of the Constitution is null and void, nunc pro tunc. Okay? From the beginning.
As far as I'm concerned, they're all non-pro-tunc because they're all revised codes to begin with.
Well, they apply to who? People they have
Let's face
jurisdiction
it.
over.
I'll make a statement, so I want you to know this. In 1872, when California put together their statutes and codes, I'm thinking it's 1872. I could be off a year or two. But there is documentation out there, I've got to get it from a friend of mine, that the codes were never passed.
Sure. There's a lot of codes, including the vehicle code.
I'm talking about the whole thing.
Which is never passed. Well, also we have a new constitution that they operate under that was never passed by the people. The original California Constitution was 1849. That was ratified and passed. California's admitted to the Union. Then they brought a new one in, which was their statutory constitution, which
Congress.
okay, and that was never passed by the people.
Co-operative Congress.
No, well, it was never passed by the people, and therefore it really doesn't apply to us. However, that's the one the court uses because that's the military one. So, but that's talking to all the statutory people, which I'm not. Okay. So that's why we talk about the organic California as opposed to the juristic California and the statutory and the legal and all that stuff. So now someone here had asked. I think you had asked about the thing the gentleman handed out, the public servant questionnaire, and about going to jail, and he's mentioned he's using it 7 times and has not gone to jail.
7 times by 7 different people for a fact.
Did you use it yourself?
I don't have to use it. If they stop me, I'm all prepared. They'll leave me alone. Where to go?
Okay. Well, would you like to share your experience with these people? Has one stopped you yet at this point?
Well, yeah, I'm sharing my experience. It's
Okay.
simple. I mean,
That'll give the people
this is
some
where
idea.
I'm coming from. That's my jurisdiction. I don't take it off.
Okay, no world order.
It's called American flag. That is your jurisdiction. And as far as I know so far, that's the only jurisdiction other than what he is using, which is administrative law. And not to be disrespectful in that sense, but I'm saying, if you look at the Constitution, what does the Constitution say? That is the law of the land. Agreed?
Yes, it is.
That's the law of the land. So what does the Constitution say about jurisdiction? You have an Article 3 court, you have an Article 2 court, and you have an Article 1 court. One's legislative, the other is executive, and the other is judicial. Which one do you want? Judicial. Where is it at? It's in the law books. It's in the Constitution. All I have to do is look it up. It's there. I rest my case. Now you mess with me and I'm going to file a criminal charge against you and I'm going to sue you on top and put your butt behind bars. I ain't going to play with you. And if the court doesn't agree with me, I'm going to take the judge off the bench by one move. I can either use the Title 42, like he's talking about, or I can use another process. The minute I use that process, they lift his bond, which they don't have. They have general insurance. They're under a general insurance pool, almost all cities. Up there in the Inland Empire, they're under what they call the Visalia general insurance pool. So they don't have bond. The Constitution says you shall have a bond. And you shall pay for it if you become an officer. If you don't want to pay for it, you're not bonded. So the minute I come after your bond, under the Constitution, you can't operate. So being that you don't have the proper bond, okay, you can't operate anyway. You can't arrest me. And every statute has to be bonded. Every process they do has to be bonded, and it's not bonded. Simply because the insurance company raised the rates so sky high that the legislature sat there and they turned around and made a revised code and took the revised code and made a public law and says we shall have general insurance only. Look up the codes in the Constitution. It's there. That's what I've done. He does the same thing. He searches. But basically, we're after our freedom, right? I don't want to take his seminar away. Excuse me. I get going. I don't want to be disrespectful, absolutely not.
Okay, so, as he was saying, that the bill of particulars has been successfully used, in his experience 7 times with police officers. And the bill of, or not the bill of particulars, but the public servant questionnaire. The public servant questionnaire is about 25, 26 questions, which I think he handed out here, which deal with questions most officers don't want to answer, because they have to deal with their public, what they tend to do with the information they're getting, and where they live, their actual home address, and they're not going to give that out, and all these other things. And if you have the